Good day. Welcome again. This is the second video. In other words, the first one was on the introduction and the background to this module and what will be expected of you. So today I'm going to discuss medical law and the Constitution, and I hope you find it extremely interesting. Just something that I forgot previously is please forgive my English with a name like Magda Slabbert. It is clear that I'm very Afrikaans. So please don't listen to my English, ignore that. Rather focus on what I am telling you and the facts that I'm given to you and enjoy what I share with you. As I've said, this is unfortunately not interactive, so you cannot respond. But in the first recording, I gave out my email address. So if you want to engage with me, you are welcome. But this is only me speaking. But today we are going to focus on medical law and the Constitution. So I'm going to share my slides with you, and then you will just hear me. But now you see that I am not a robot. So let's just quickly share my screen. And you see I'm old, so sometimes it takes a while to get to where I want to be. Okay, there we are. Medical law practice. This is the second recording, and it is medical law and the Constitution. Okay, as way of introduction, there's sometimes just not confusion, but different words used. Healthcare law is much wider than just medical law. But it doesn't matter how you use the words. The same with medical negligence, medical malpractice. People use it interchangeably. But remember that medical law or healthcare law are much wider than just medical negligence. In other words, there are other areas to be explored under healthcare law: in vitro fertilization, organ transplants, mental health. All those things fall under the umbrella of healthcare law or medical law. What is more important that you should know is that South Africa have two sectors. We have a public sector, public funds, public hospitals, and we have a private sector. Just note that there are negotiations and things happening now about national health insurance that is envisaged for 2026. So until that time that happen, if it will happen, we will see what happens in future. You must know that in medical law or in the healthcare context in South Africa, there is a public sector and there is a private sector. As I've explained in the previous recording, the public sector is provincial. National government, National Department of Health gets an amount, and then it is allocated to the 9 provinces where we have the head, the premier of the province, and part of his team, the MEC for Health, who must then administer the budget for the public sector in that province. The private sector, on the other hand, they function independently. Very important to know at this stage that the doctors and the nurses working in public hospitals, and when I speak about doctors, it is generic, it is inclusive, let's say, of physiotherapists, speech therapists, dietitians, all of those in the public sector work for the state. So the state is the employer, and all those people, the nurses, the doctors, the physiotherapists, all of them are employees of the state. In other words, they get a salary from the state. This is important for you to know, because as we go on and I discuss all the other things, you will see that vicarious liability, where the employer is responsible for the acts of the employee, comes into play. In the private sector, on the other hand, doctors are always independent contractors. In other words, doctors do not work for private hospitals. Nurses are a little bit different and more complicated. A private hospital may have nurses who are their employees, but they can also use an agency and ask an agency if there is a need for extra nurses, and then the agency will provide the nurses for a specific time, and then those nurses are not employees of the private hospital. So this is very important. In the public sector, those people in the healthcare scenario are employees of the state, and a vicarious liability is applicable. In the private sector, they work for themselves. They are independent contractors, and be careful of the nurses. Nurses are not automatically employees in the private sector. They may also work for an agency who then supply the need for nurses at private hospitals. Okay, so keeping that in mind, then we have in South Africa our constitution, the Constitution of the Republic of South Africa, 1996. And the constitution is always in the background because it's the highest law in our country. And anything or any legislation that is against the values or the stipulations in the constitution must then be declared invalid. So it is quite important that we must look at the effect of the Constitution in a medical law scenario. And that is what I'm going to talk on today. But before we focus only on the Constitution, I want to create a scenario for you. Where are we going? And I want you to understand what I'm going to say today. Remember, in the previous recording, I said that everything that goes wrong in hospital or with a patient's treatment is not per se medical negligence. We have to apply certain criteria in order to determine whether there was negligence or not. I'm going to give you two examples, and I want you to see the difference. Let's say, this is now hypothetically, I have a son of 19 years. In other words, he's already a major, not a minor anymore. But he's a student. He lives with me. I take care of him. He is not married. He doesn't have children. He is not supporting anybody. I, the mother, am supporting him. So one night he goes out for festivities, had a few drinks. Sorry, I'm just drinking some water. And there's an accident. He is taken to hospital via ambulance, and then in hospital, he dies because of negligence of the hospital staff. What now? I've lost my son. Of course, this is terrible. And I am angry, but I will not be able to sue either the hospital or the doctors. And this is terrible, but this is a fact. I am not just saying this to you. This is the bottom line of medical negligence cases. And you must grasp this because you have to determine what damages were suffered. Nothing in that scenario, aside from my pain and my suffering as the mother, but my pain and my suffering is not quantifiable. In other words, I cannot go to court and say this hospital was negligent and now I am claiming 20 million because I lost my son. No, that will not happen. That cannot happen because pain and suffering is not quantifiable. And I want you to go and read the case that I've indicated there, Mbele versus MEC for Health for Gauteng. It's a Supreme Court of Appeal case. And it is important that you go and read that case. What happened in that case is that she gave birth to a baby, to a stillborn baby. Then afterwards, she was taken to the maternity ward and she had to go to the mortuary to identify the little baby. That was cruel to do that. And then she suffered a lot of psychological problems and she needed help. And therefore, she approached the court and said, I had so much pain and suffering. I had to go for psychiatric help, and a psychologist was involved. In other words, there were invoices, there were amounts that quantified her pain and suffering. And in that case, the Supreme Court of Appeal allowed 100,000 rand for her for the pain and suffering. But that is the exception. She could quantify it. She could prove how she was suffering. And in that case, a few other cases are quoted that you must take cognizance of if you want to claim for purely pain and suffering. Let's go back to my hypothetical example, and I'm changing the facts a little bit. It is still my son of 19. He went out, had drinks. There was an accident afterwards. He was taken to hospital. He did not die, but because of negligence in the hospital, he is now paralyzed. He's not dead, he's paralyzed. Okay, now the scenario changes because now he himself can institute an action against the negligence of either the doctor or the hospital. Remember, I said he's 19, so he's above 18, so he can institute action in his own name. And now he can claim 20 million or even more, because he will now claim for all the damages he suffered. In other words, the loss of amenities of life because he's now paralyzed, the possible earnings that he would have earned in future, his own pain and suffering being a paraplegic now. Then he has a case, and I hope you see the difference between the two. If he died and he was not responsible for anyone to support, then I, as the mother, have no claim, because I cannot just claim pain and suffering that is not quantifiable. But if he is paralyzed because of negligence, then there's a huge case to be made out and millions can be claimed. So I hope you grasp this. I hope it will also become clearer as we go on. Now, what is the bottom line? Why do I tell these examples to you? Because I want to show to you that one of the biggest parts that you will have to prove in medical negligence litigation is the amount of damages. The amount of damages. If you can prove damages, you have a case. In our medical law litigation process, medical negligence, etc., when you go to court, you have two choices on what basis to institute action. It can be on the basis of a delict, or on the basis of a contract, or even on both. You can have both, or the one or the other. You will see that the majority of medical negligence cases is on the basis of a delict. Very few on the basis of a contract, but you can have either or both. So it's usually safe to go on both. But as I say, the majority is based on a delict, meaning that when you base your claim on a delict, the duty of care that the hospital or the doctor had, you will have to prove the requirements of a delict. And the requirements of a delict, just side note, a delict is when some a person harmed another person, and that person who was harmed suffered damages. So you will have to prove in court there was conduct. In other words, a person did something. The doctor did something. What he did was wrong, wrongfulness. It was fault. Now, in medical negligence, fault is usually negligent. Fault can be either intention or negligence. But in our world of medical negligence, then fault will be that the doctor was negligent. Causation. You have to prove that there is a link between what the doctor did and the damages that you suffered. So you have to prove the doctor acted, he acted wrongfully, he was negligent, there is causation, there is a link between what happened and the damages that the patient suffered. You must prove all of those. All of those. And the difficulty in medical negligence is to prove causation and to prove damages. I'll come back to this and you will understand this completely at the end of the module. Contract, there are certain requirements for a contract, and I will come back to that. Those of you who have an LLB, can you still remember what are the requirements for a valid contract? Sorry, I'm just drinking water because I'm talking so much. Okay, so that is where we're going. But before we can get there, before we even entertain the law of delict or the law of contract, we have to focus on the Constitution, as I've said, because that is the highest legislation in our country. So first of all, look on how you reference the Constitution. It is the Constitution of the Republic of South Africa, 1996. You do not say Act 108 of 1996 because there is a certain piece of legislation that say that the Constitution must be referenced as I did. So do not say Act 108. Okay, so you are all aware of our Constitution, and our Constitution have in Chapter 2 the Bill of Rights. So we are going to discuss some of those rights, those human rights in Chapter 2 of the Constitution, the Bill of Rights. And the first one that I want to focus on is the right to equality, and it is Section 9 of the Constitution. Now, I want to come back to private and public. In the public sector, the doctors and the nurses are employees of the state. In other words, they cannot choose whom they want to help, whom they want to treat or not. They have to follow their contract of employment, and they have to treat every person that comes to them in the public sector, even if abortion is required. According to the Choice on Termination of Pregnancy Act, it is legal to have an abortion in South Africa, and a girl or a woman from any age can go to a place and ask for an abortion. Now, if that happens in the public sector and it happens to be a doctor who do not believe in abortion, it is against his or her culture or religion or whatever, which is also protected in the Bill of Rights, they don't have to do the abortion, but there's a legal duty on them to refer this girl or this woman to someone who will do it. In other words, they cannot just tell this girl child, I don't do abortions, it's completely against my religion, so I will not do it. That is wrong, and you can be prosecuted for that. So you must tell the girl child, you will not do abortions because it is against your religion or culture, but I refer you to another doctor who will do it. That is your duty. You have to do that. Okay, so abortion is an extreme example, but just note that in the public sector, doctors, nurses, physiotherapists, all other therapists, they are employees. They must follow their contract of employment. They have to treat whoever presents in front of them. The private sector is different. The private sector, as I've said, all doctors in the private sector are independent contractors. They are not employees of a hospital. Nurses, as I've indicated, different. Nurses can be employees of a private hospital or they can be employees of an agency. But let's come back to doctors in private practice. They can choose whom they want to treat or not, meaning they can, for example, say that on Mondays, only up till 12 o'clock will I see patients. On Wednesdays, I will not see any patients because I'm playing golf on that day. They have that freedom because they are working for themselves and not for an employer. They can also say that I will only treat women with reproductive health issues. That is also fine. But they're not allowed to discriminate. In other words, private doctors cannot just have a practice for white people only. No, that is discrimination that will be not allowed. They cannot also say, I will treat everyone except homosexuals. No, they cannot do that. That is against the Constitution and that will come down to discrimination. So although the doctor have leniency how to run his or her practice, they are not allowed to discriminate. They cannot discriminate because then that is against the Constitution. Okay, the next right that I'm going to discuss is human dignity, section 10. Now, in the case of State versus Makwanyane, that was the case concerning the death penalty, it was said that human beings are entitled to be treated with respect and concern just because they are human. In other words, every person, every patient, the family of the patient, the staff, the colleagues, etc., must be treated with dignity because they are human beings. But you must also treat yourself with dignity because that is where it starts. If you are proud of yourself and you would like to be treated with dignity, then you must also treat others, the patient, the family of the patient, staff, colleagues, everyone with dignity. And this comes into play in when I'm going to discuss euthanasia later. It is difficult. It is sort of a fluffy concept. What exactly is dignity? But every person has the right to claim to be handled with dignity. I'll come to this again when we discuss the right to life. Okay, the right to life is section 11. Now, every person in South Africa has the right to life. There I have indicated two court cases. The first one is Transom Fort versus Minister of Justice, and it went to the Gauteng Province High Court. Mr. Transom Fort was dying. He was terminally ill, and he had immense pain. And the suffering, there was just no end to this suffering. So he approached the court and he told the court that he is going to die. It is just a matter of time. He will eventually die. He's terminally ill, but he is in immense pain. So he asked the court to be allowed to have a doctor to assist him to die. In other words, he wanted the doctor to give him some pills, some medicine, or an injection so that he will die. He doesn't want to live anymore. There's no prospect of being cured. He is just in immense pain. His life has no value anymore. And he would like a doctor to assist him so that he can just die peacefully and then, of course, be free of pain. Unfortunately, the court case happened. And on the day that the judge was going to give judgment, that morning, Mr. Stransomford died. So he never heard the outcome of the judgment. And the judgment was in his favor. The court said, for his own dignity, they will allow that a doctor can assist him so that he can die peacefully. He died that morning. So, judgment was given, but then the Minister of Justice went to the Supreme Court of Appeal. And that's the second case that you see there. And they argued that the High Court should not have given judgment because the plaintiff died and was not alive, was not living anymore when judgment was given. So that court should not have given judgment. And the appeal was upheld. The Supreme Court of Appeal said, yeah, they're not going to allow physician-assisted suicide at this stage because there's more research that need to be done in order to legalize it in South Africa. So those two cases are sad but interesting. And then in February, a Mr. Haak went to the High Court and asked for the same thing. He wanted to be allowed to be assisted when the time comes that he cannot help himself anymore. He is also terminal. His life has no value, but he is still compos mentis at this stage. So he's asking the court to have the right to end his life should it become unbearable. It was supposed to be handled in court again in September this year, but I have heard nothing. So just please keep your eyes and your ears open if it is in the media or something happens with that court case. Okay. Then there are still on equality, which I've discussed. There is legislation promulgated in terms of that, the Promotion of Equality and Prevention of Unfair Discrimination Act. Then you should also take note of Section 12 of the Bill of Rights, the freedom and security of the person. Very important. Why I have an exclamation mark there is because this is the foundation for patient autonomy and eventually for the concept of informed consent that we are going to discuss later. Then everyone has the right to privacy. That goes hand in hand with the confidentiality between a patient and a healthcare worker. And as I've said at the beginning, the Health Professions Council of South Africa booklets, there's a specific booklet on confidentiality. And then also please note that in South Africa, there is no right to healthcare. People sometimes use the words wrongly and then it creates the wrong impression. We only have a right to access healthcare facilities or healthcare personnel. In other words, it's the right to access to healthcare, and that is Section 27. We do not have a right to healthcare, only a right of access to healthcare. And there is a very interesting court case, which I also, if you are going to work in this field, that I propose that you go and read the whole case, or you can Google it and get summaries of the case. But in Subramani versus the Minister of Health, KwaZulu-Natal, it ended up in the Constitutional Court. Now, what happened in this case is Mr. Subramani had kidney failure. If your kidneys doesn't work, then you die unless you get dialysis in a hospital. So Mr. Subramani went on dialysis in the private sector where his medical aid paid for it, etc. But it is very expensive, very time consuming to go on dialysis, and Mr. Subramani's money ends. There was no more money to pay for dialysis anymore. His funds were depleted. So he went to the public sector in KwaZulu-Natal and he asked to be placed on the dialysis program of the public sector hospital. Unfortunately, Mr. Subramani, apart from having kidney failure, he had other illnesses as well. And in the public sector, the criteria to be placed on dialysis is that you should be healthy enough to be a candidate for an organ transplant. As an interim measure, you are then placed on dialysis until an organ becomes available for transplantation. So they refused Mr. Subramani access to the dialysis unit because they said because of his other illnesses, he is not a transplant candidate and therefore they cannot accommodate him on the dialysis program. So what basically happened is that they sent Mr. Subramani home to die, and he died. Then the court case, the constitutional court case said that, first of all, to be on a dialysis machine is not emergency medical care. Secondly, the state, the public hospitals have limited resources, and therefore they can have a policy to say who will be put on dialysis and who not, because of the lack of resources. And this is why this case is so important, because a lot of time when things go wrong in the public sector, they fall back on this court case and they say, we do not have resources. And as I've indicated to you, the money that goes into medical negligence claims, a little bit of money left to invest in public hospitals. Therefore, there is a scarcity of resources. So if something goes wrong, then the state or the public hospitals say, we are sorry, but we had a lack of resources. Myself, with all due respect to the Constitutional Court, I feel that this should be challenged again. This case happened in 1998, and we are already in 2022. And I feel similar facts should be challenged again, because I think it became, after this case, too easy for the public sector to say, sorry, we couldn't do anything, lack of resources. But that's just my opinion. Read the case and make up your own mind. Then also in the Constitution, the rights of children, which is section 28. Sorry, I'm just drinking water. Whenever clients come to you for alleged medical negligence and children are involved, you must see a red flag. Be careful. Children are not just children below the age of 18. The most important right of children in the Constitution is the way they tested the best interest of the child. That is the golden words, the best interest of the child. But you have to consult in tandem with the Constitution, the Children's Act, and maybe if it concerns abortion or what, the Choice on Termination of Pregnancy Act. It is very important because the Children's Act distinguishes between children below the age of 12 and children above the age of 12 who are mentally matured to understand what is happening. So I'm not going to go into detail now. As we carry on, I will refer back to this. But all I want you to know today is that when you work with children, be careful. Remember section 28 of the Constitution, the golden words, the best interest of the child, and then you must, in tandem with the Constitution, consult the Children's Act. Okay, then access to information is Section 32 of the Constitution, and there is another piece of legislation promulgated in tandem with Section 32, the Promotion of Access to Information Act. If you want to see how that act was applied to a medical negligence claim, you can read the Unitas Hospital versus Van Wyk, 2006, and it went to the Supreme Court of Appeal. That, if you read that case, you will see how to work with the Promotion of Access to Information Act. Okay, so here are a few constitutional court cases. Why do I emphasize these? Is because of our system of a president in South Africa. So you must follow the judgment of constitutional courts, then the Supreme Court of Appeal, then high courts, and then magistrates court. So it is very important to take note of the constitutional court cases in alleged medical negligence or in medical law per se. So I've discussed the Subramani case. You can go and read it on your own. The second bullet there, Chabalala Mzimang versus another, that is our previous Minister of Health that needed a transplant, etc., and things were splashed in the media, and then she took them to court on the basis that her privacy were violated. So that case concerns the right to privacy. H versus Fetal Assessment Center, a 2014 case. Very important. And I will suggest that if you have time to read that case, it is very important because it concerns cases that happens on a regular basis in our courts. In South Africa, when something goes wrong in the area of gynecology, there are 3 claims that you can institute. The first one is wrongful pregnancy or unwanted pregnancy. That happens when either the woman, she went for a sterilization, or the man, he went for a sterilization, and they have concluded with the hospital and the doctor that the sterilization will be done, only to have sex afterwards and falling pregnant. So something went wrong with the sterilization, and a baby is on its way. Then you can go to court, and your claim will be an unwanted pregnancy or a wrongful pregnancy. You will then have to prove to the court that you went for a sterilization, that the doctor did not do the sterilization correctly. In other words, it's a faulty operation. You were not sterilized. And now the causation, you are pregnant. What are the damages? All the money to look after this child, raising this child. So you will claim the upbringing cost for that child, because that you shouldn't have fallen pregnant, but you did because the sterilization was not carried out correctly. That is absolutely acceptable in our legal system, and you will see there are cases on that. And then the amount of damages will be the total cost to bring this child up until the age that he or she can look after themselves. The second one that is a possibility in the same field of gynecology is unwanted birth or wrongful birth. This is where a woman, she fell pregnant. They wanted to have a baby. The woman then goes to the doctor or the gynecologist and say, please do some tests, because I want to know that this baby in my uterus is normal. There's nothing wrong with the baby. Because if there is something wrong, if you can detect spina bifida or a Down syndrome or any other defect in the fetus, then I would rather opt for an abortion. That is the right of a woman. The woman can ask that of the doctor. Now the doctor do the tests and negligently do not see that there is some or other fault with the fetus, some or other disability. So he overlooks that. He doesn't see that. He interprets the reports wrong, or he did the tests wrong. Whatever the case may be, so the baby is born and it is a disabled baby. Then the parents of that baby can go to court and institute an action and say, we wanted a baby, but we did not want a disabled child. We specifically asked for tests, but you gave us, the doctor now gave us the wrong information. And now we as parents must look after this disabled child. So we are claiming damages. We want money to look after this child. We as parents need money to look after this disabled child for all the medical things that he or she will need in future, all the therapies, all those things. And they will quantify it. And that is also acceptable and legal in our legal system. And you will see there are cases on that. I will tell you as we carry on. The third claim in our legal system was unwanted life or wrongful life. It is more or less the same as unwanted birth, but it changes a little bit. Here, the women also go to the gynecologist to do tests. The gynecologist negligently say there's nothing wrong with the fetus, and when the baby is born, the baby is disabled or abnormal. Then, in wrongful birth, it's the parents that goes to court. In wrongful life, it is the child that goes to court. Of course, the baby cannot go on its own. He or she will be represented by the parents. But it is the baby that say, I should never have been born. So the child say, I should never have been born. Now I am born and I am suffering. Therefore, I am claiming an amount to look after myself for the rest of my life. So when the damages are awarded, it is awarded to the child. That was contra boni mores, against the morals of society for many, many years, until 2014 in the Constitutional Court case of H versus Fetal Assessment Center. In that case, the Constitutional Court said that a claim for wrongful life is not contra bonis mores anymore, and it is now allowable in our high courts as the basis of a claim. And that is phenomenal. So after this Constitutional Court case, a baby can now sue the doctor with the help of his or her parents for the upbringing cost, because there was negligence in determining whether the baby was normal or not normal. Very, very important court case. Nice to read and to take cognizance of if you are going to practice in the field of medical negligence. Lee versus Minister of Correctional Services. That is a long and a difficult case, but if you want to understand legal and factual causation If you want to understand that very well, then go and read that case. It's the person that went to prison, to the correctional services, and then contracted TB. And the judgment focus on causation, and that will help you to understand causation. About that case, sad case, nice case to read. If you don't want to watch Netflix over weekend, read that case. It is sad. It's a rugby player with a back injury that was sent from pillar to post, from this hospital to that hospital to that hospital, and eventually ended up a paraplegic. And he took the Department of Health of the Western Cape to court and said that his right to emergency healthcare was violated. What is also extremely important in that case, there were two teams of experts, one for a team for the plaintiff and a team for the defendant. And then the court went with the one team. And my instincts say I would have gone with the other team. So read that case and see the different attitudes or the different way the experts came across. And then just ask yourself whether you would have gone the way the court did in favoring that team of experts, or do you think the other team of experts was better or more logical, etc.? Decide for yourself. It's just very, very interesting. And then the last bullet on this page is the MEC for Health versus DZ. Also still a constitutional court case. Extremely important. You cannot actually practice medical negligence without taking note of this case. In the past, when you claim on the basis of medical negligence, you would claim once and for all, and then the court, if you are successful, will say that the MEC must pay you out a lump sum in money. The once and for all rule is that, let's say a baby is now born with cerebral palsy, and the mother was not warned, so they now claim for the upbringing of that disabled child. They will claim past medical costs, future medical costs, the possible loss of earnings, loss of the amenities of life, and all that will be quantified, let's say 30 million. And when successful, judgment will be given that the parents must get 30 million in a lump sum. And it is done once and for all. They can never go back and claim more for this child. That is how it used to be. But then, as you've seen those numbers of the different provinces that they spend on negligence cases, this case came to the Constitutional Court and said, we do not want to pay once and for all. We as the public sector would rather provide the services in the public sector, all the therapies, all the medical needs of this child. We will rather provide it than give the money for it. And in this constitutional case, it was said depending on case by case. But it is a valid argument to say we're not going to pay out a lump sum anymore. We're going to pay by means of providing the services. And we're not going to give one lump sum. We will pay the lump sum as and when necessary. So that changed the way that you claim for medical negligence cases. And it is important to take note thereof, because depending on the facts, when you go to a high court, then the defense, the state can say, we are not willing to pay once and for all, and we are not willing to pay a lump sum. And they will have a valid argument based on this constitutional court case of DZ. And then on this slide, you will see quite recent cases, 2022, 2021, etc. All three cases went to the Supreme Court of Appeal. The Constitutional Court has widened their jurisdiction, and um, you can go to court and then argue that it is in the public interest that this case be heard by the Constitutional Court, but you will have to prove that it is in the public interest. And if you go through those three very recent cases, you will see how the Supreme Court of Appeal handle, because these three cases are purely medical negligent cases. But it was appealed again and it ended up in the Constitutional Court. So these three cases is a must if you are practicing in medical negligence cases. Okay, then just something interesting that also went to the Constitutional Court. The voice of the unborn baby and another versus the Minister of Home Affairs. I was involved in this. This is an NGO. But what it basically comes down to is that when you have a miscarriage, in other words, you do not carry the baby in your uterus full term, the 9 months. If it is before 26 weeks in the uterus, and there's a spontaneous abortion or a miscarriage, then that baby becomes medical waste per se, and it goes to an incinerator. If the same thing happened at 28 weeks, then it is considered a viable fetus and it is a stillbirth, and there's a death certificate. So the argument was that that is not fair because every woman experiences pregnancy different. So you might get a woman who has a spontaneous abortion or a miscarriage when the fetus is only 24 weeks, and that woman wants a burial because she wants closure, because she already loved this child. She wants to pay tribute to this child, but then she was not allowed to because it has to go to medical waste. So it was taken to court to say that that was discriminating against a category of parents, those of a non-viable fetus, whereas those of a viable fetus they can have a burial. You can't have a burial without a burial order according to the Birth and Death Registration Act. And then it was argued that it must always be the parents' choice whether they want the fetus or not. But then the Constitutional Court said that BADRA, the Birth and Death Registration Act, does not specifically say or address pre-viable fetuses before 26 weeks. It is the Act doesn't prescribe that it must go as medical waste. The Act doesn't address it at all. It just became practice in hospitals that it goes to the incinerator as medical waste. But the judgment basically they now say that all mothers can ask to have the what is left over of the baby to go and bury. There is a difficulty still with municipal bylaws because municipal bylaws wants a certificate, a death certificate before a burial is allowed. And they still refer back to the Birth and Death Registration Act. So that is another challenge that has to be overcome before all miscarriages can have burials as the parents wish. So that is just for interest's sake. And then there's another Constitutional Court case, which I will discuss when we discuss criminal liability of doctors. But just to have all the Constitutional Court cases together, I mentioned this now, Van der Walt versus the state. It's a criminal case that ended up in the Supreme Court of Appeal. Okay. Before it's the end of the slideshow, but I still want to quickly talk to you. So I just stop sharing. Just stop sharing. Okay. So that is now your first unit that you have to study for test one is the theory in your unit on the website. So you have to study it, and once you feel comfortable, then you can write test one. But you must feel comfortable of all the theory in all the units. There's just something that I would like to add, coming back to Stransom Ford and the right to life. You will see it's also discussed in your study material. Euthanasia is illegal in our country. Euthanasia meaning to let a person die. But we get active euthanasia and we get passive euthanasia. Active euthanasia is when the patient is suffering and the doctor actively go and inject the person, and then the person died. That is basically murder, and it is illegal and not allowable in our legal system. But then you have passive euthanasia. That is where a person is terminally ill. The prognosis is terrible. The person will not ever be normal again. And the person is kept alive artificially. Artificial feeding through drips, etc., or artificial ventilator that keeps the lungs going, etc. Then if the doctors reaches a stage where they realize there's no hope for this person, they will call in the family and they will discuss it with them, and then they will come to a conclusion: let's stop feeding, let's stop the machines. And that is passive euthanasia, because when you do that, the person will eventually die. Maybe not immediately, maybe a few hours after switching off the machines, but that is passive euthanasia. It is also technically illegal in South Africa, but it happens. It happens, but it depends on the diagnosis and prognosis of medical people, medical experts, and the family. And it's a decision taken by all relevant parties, and then the person is allowed to die. And then there's another one, physician-assisted suicide, which I discussed, the Stransom Ford case. So that is currently illegal in our legal system. You are not allowed to be assisted to die. Some of you might know about the story of Sean Davidson, who helped people to die in South Africa, and he was sentenced to 3 years house arrest. So he was not allowed to leave his house for 3 years. But this is a very current debate, and you can think or decide for yourself whether you are for or against it. But those who are for it say that it is based on human dignity. People want to die with dignity. So yes, you have the choice to commit suicide. In other words, you can take a gun and you can put it next to your head and shoot yourself to death. But that is so undignified, because then someone must come after and clean up. And then the people say it is much more dignified if you are terminally ill and if you are in constant pain to be helped to die, to leave this earth. But it is still a debate. So currently, when you are asked the question, you have to say that it is illegal in our legal system. Hand in hand with that goes a living will. A living will is a document that you write while you are still very healthy and understands everything. And then you write in that document that should circumstances change, you in an accident or you become ill, and it changes to such an extent that you will be kept alive artificially with machines, then that document say, please do not do that. Please rather let me die. In other words, it is a document that tells the doctors and my family what I want should happen with me when I am not capable of taking my own decisions anymore. This is not a valid document in our legal system. In other words, it is just a directive. It is just a directive to the doctors and the family members of what the patient would have wanted to happen. But you cannot go to court on the basis of a living will. You cannot sue on the basis of a living will. It is not yet a legal document in our legal system. Okay, so in your study material, you will see there are exercises at the end of the theory, what we call practical exercises. So you will see the first one there is the family that have the child who suffers from Down syndrome. Now, in order to answer that question, you must go back to where I discussed H versus the fetal assessment clinic. And then you will, with all that discussion that I gave there, you will be able to answer the first exercise, your practical exercise. The second one is the child who is 14, who then wants the blood transfusion. Remember when I said that when children are involved, the Constitution say the best interest of the child? The Children's Act say in section 129, a child of 12 years who is mature and who understands what's happening to him or her can consent to surgical operation or medical treatment. They do not define what is maturity or how is it determined. But if you go to section 129 of the Children's Act and you apply that to the second exercise, you will be able to answer that. The bottom line is that Tandu is 14, so he will be able to decide for himself whether he wants the blood transfusion or not. His parents can only assist him and affirm his specific choice. Okay, so I've spoken quite a lot today. I hope you've learned something and I hope you are enjoying the module thus far. But this is then the end of the recording for this unit, which is medical law and the Constitution. See you again next time.